Did there come a time that you lost that job?
There did.
And why was that?
Due to COVID-19.
All right. And when was that?
That was this July.
And since that time, have you started on another career?
Yes, sir, I have.
And what is that?
I work in the real estate industry.
All right. Now, do you know Robert J. McDonald?
I do.
And how do you know him?
I am his sister-in-law,
And he married your sister by the name of?
Lauren Hoover.
All right. And how long have they been married?
They have been married since December 14th of 2019.
Okay. So, during, were you around when they were going through their courtship leading up to their marriage?
Yes, sir.
And how long a period of time was that?
That was from literally right after they met to 2017.
Were you able to observe Robert McDonald's actions in and around your family and your sister?
Yes, sir, I was. I lived with him for a period of time.
Okay. And how did they get along?
Rob was quickly accepted into my large family. Everybody was living at home except for my older brother, because my sister was getting her master's degree and was living at home. I was moving home because I was attending college and my little brother was in high school. So Rob moved into our house because he was not living at his house anymore due to circumstances. And he actually took over my childhood room, and he just quickly became part of the family.
And just give the court a couple of instances of what may or may not have occurred while all this was going on.
Yeah, so Rob and my sister met. This incident occurred. Rob had to travel back and forth to Macon. He lost his job. He lost his place where he lived. He was living with his family and with our family split time. He went back to school to become an airplane mechanic, so he could get a job there to provide for his now family, my sister. Rob has been ingrained in our family since the day that we met him. He cooks out for our family. He goes to the grocery store. He helps the dogs. He actually took over taking care of my dog that I got when I was in college and realized that I couldn't take care of the dog, being a collegiate athlete, and Rob took over the responsibility of that. He has helped with a numerous amount of things in my family. He is the one that always, when we forget something on family holidays, he is the first one to hop up, go to the store. Somebody texts us, oh, we forgot this. Oh, just ask Rob, he's already out. Rob cooks for our family. He sets the table, he cleans the table, he does it unprompted, always the first person to lend a helping hand. Rob, I remember an instance where I was at work and I forgot part of my uniform that I needed, and Rob hopped in the car and drove 30 minutes to bring it to me. Rob is a staple in our family, and he has been since day one, and I cannot imagine our family without him.
All right. What is Rob's general demeanor around you and your family?
Rob is my brother, so Rob is, I have never seen him raise his voice. I have never seen him get upset. I have never seen him in a position to even if he is rightfully so allowed to be upset, I have not seen him even bat an eye. He is controlled, he is sweet, he is caring, he is gentle, he loves my sister so well, and I could not be more thankful for a brother like Rob.
Well, now let's turn to right after the trial. Now, the trial went on, and your father, he was here every day, pretty much. Is that a fair statement?
Yes, sir.
Your mother, she didn't come, is that correct?
No, sir.
Right. What happened about 2 days after this trial concluded?
So, about 15 hours after the verdict was read, my mom collapsed on the floor of the kitchen in our childhood home and was rushed to Gwinnett Medical and was diagnosed with a hemorrhagic stroke. And so that was Friday morning at 9:21, my dad called me. The last conversation I had with my mom was her giving me the news of Rob's verdict. After my dad called me, I rushed to the hospital. Rob was the first one to greet me in the parking lot. He was the first one to take me to my mom.
And then your mother passed.
And then we spent Friday in Gwinnett Medical. Saturday we had to move her to the top neurosurgeon in Atlanta and Emory. And then Saturday we spent all day at Emory, Sunday all day at Emory. They allowed us to have time to let our family fly in to say their goodbyes. And then Sunday at 11:40, we stood around my mom as we took her off of life support and watched her pass away.
And Rob was there, correct?
Rob was, that is an understatement, Rob was in my mother's hospital room day in and day out overnight. He never let my mother be alone in that hospital room.
Now, a little bit after that, your father had to have some surgery, is that correct?
Yes, sir.
What was that?
So 2 weeks after my dad had to undergo spinal surgery, and we were all working, and so the caretaker, the primary caretaker of my dad would have been my mom. She was not there. Rob had to step in and help. He moved back home and with my sister to my dad's house to take care of my dad. He took him to and from his doctor's appointment. I was able to take off work and go for the day of surgery. Rob drove us. He drove me. He sat in the waiting room with me. He got my dad's medicine. He was there day in and day out with my dad to help him. He cooked for my family. He cleaned the house. He took care of the dogs. He did everything because my dad was recovering from spinal surgery.
What are you asking the court to do in this case, as far as civil?
I am please asking you, we have lost our matriarch of our family. My family we have been shattered. We are heartbroken. Rob blames himself for my mom's death. He apologized profusely to my family, to my mom as she was dying. He has to carry that burden every day. I cannot imagine the weight of that. I am please begging you through this terrible year, through this holiday season without our mom. My sister has to go through that. Please do not take her husband away from her. Please do not take the person that has been the glue to our family away from us.
Thank you, Judge. That's all the questions I have.
I have no questions for this witness.
You can go down.
Garrett Meyer. May she remain in the courtroom, Judge?
She can.
Raise your right hand. You swear that the evidence you should give in this matter now being before this court that being the case of the state of Georgia versus Robert J. McDonald, indictment number 19B-03549-10, shall be the truth, the whole truth, nothing but the truth, self as God, or you so affirm?
Yes.
Have a seat.
Sure.
State your name for the record.
It's Garrett Ethan Meyer.
And what do you do for a living, Mr. Meyer?
I'm a mechanical engineer.
All right. And how long have you been a mechanical engineer?
About 5 years now.
What is your, basically, where did you live, grow up, and what's your educational background?
I grew up in Columbus, Georgia. Dad's a retired fire chief. Mom's also retired. Been married for about 2.5 years now. Got a mechanical engineering degree from Georgia Tech and a Bachelor of Science from Berry College.
How long have you known Robert J. McDonald?
About 10 years now. We met at Berry.
And when did you meet at Berry? What year?
My freshman year, 2010.
Have y'all continued to stay in contact throughout the year?
Absolutely.
And what type of person is Robert?
It's hard to say enough about Rob. He's just such a good person. He's kind. He's courteous. He's orderly. He's an incredibly hard worker. And he's always been a positive influence on me.
What are you asking the court to do with this matter, as far as sentencing goes?
I just ask that there be a very lenient sentence. He's just such a good person. He has a lot to offer this world. He's got a good education. He's got a good heart, and he's an incredibly hard worker.
Thank you, Judge. That's all the questions I have, Mr. Meyer.
Ms. O'Neill,
I have no questions for this witness.
you can go down.
May he also be excused from
You
the
can
stand
remain.
and
You
be
can
allowed to
report.
remain?
Pardon? You can remain. Sure.
Thank you, Judge.
Who do you call next?
That would be all we would do, call, Judge. We would, rest at this time with the tendering of our documents and that testimony, and then, our, argument, on appeal, fear, and allocution from the defendant, whatever.
You've already made your recommendation,
We have, Judge.
then I'll hear from you.
Judge, this has been a very troubling case for me from the get-go because of the difference that the prosecutors, and I'm not just grouping the district attorney's office, but also the solicitor's office in this too, how this matter has been handled throughout the time. Now, in this case, Judge, you will see in the court, it's before the court, because we filed a Rule 404B. And attached to the Rule 404B, there was a ruling, the court has had that ruling before during court, and there were various arrests that were allowed in, and some were not allowed in on this property. We entered into this court today that there, in fact, the times that Mr. Hollins was in custody in Gwinnett County. So the court can see from that there have been at least 10 arrests. And the court will recall from the testimony in this case how he was dodging probation violation warrants and new warrants that had been taken out for him, and what he said he was doing during that period of time, and how he was living his life, and how he was not doing anything. Now, it's important for the court to know that the only charge in this case that he was arrested for on that day, that he was not guilty of, was the obstruction of Bon Giovanni. But he admitted to all the others. He had the marijuana, he didn't have the license, and we went through that, Judge. Now, the state says, why did they cover it up? Why did they cover it up, is what she said. We were never charged with covering up anything. We were never charged with violation of oath of office that involved anything with any type of covering up. But if the court will recall the testimony of Mr. Bon Giovanni in this case, and the numerous counts that he was charged with, as far as the obstruction went, he pled, in this case, Judge, and I know the court will recall it, but I want to say it for the record, he pled to the aggravated assault. He pled guilty with an offered plea, a no contest. They dismissed counts 2, 3, 4, 5, and 6, which were counts of violation of oath of office and false official certificates of writings. And false official certificates of writing again. There was 2 counts of that. He was charged with covering up. Not this man, but the state of Georgia dismissed those charges. The state of Georgia made a deal with Mr. Bon Giovanni, who was the instigator of this, who started it all, who unprovoked struck the man. We came upon the scene, Judge, and you heard our testimony. What did the state do in Mr. Bon Giovanni's case? Well, they let him plead that, as I said, and they gave him a total of 10 years. But the one thing I didn't bring out at the trial that I wish I had in this case, and it just slipped my mind, and the court knows how things slip your mind when you're doing things. The state agreed, and the court entered a sentence that included a behavioral incentive date of June the 11th, 2022, in accordance with the law. And because he had had no prior felony conviction, and he hadn't been sentenced under prohibited acts, and he was sentenced to straight probation or not more than 12 months confinement followed by probation. And that includes the behavioral incentive date not to exceed 3 days from the date of the sentence. So 3 days, 3 years, from the date the sentence was entered on June the 11th, 2019, he's free to bird. What else did they do, Judge? They got him for a probation supervision fee, and they got him for a $1,500 fine. But they agreed in this case that he would serve a period of house arrest of 5 months, and that he would serve work release of 6 months. The house arrest to follow the work release, so less than 12 months. They granted him first offender, which we also request this court in this case. Granted him first offender, but not only did the state agree to it, but his record was sealed early under the law. They agreed to it in open court to allow him to enter upon this sentence and to, in fact, get his first offender from the get-go, where I had to get a court order. And none of these people have ever seen the sentence. I had to get a court order for me to be able to use it at court. I had to file a motion, we had to have a hearing, and the judge had to enter an order telling him to give me the paper. That's what they did for Mr. Bon Giovanni. And then what about Mr. Hollins? Well, the court will see from the documents that I've submitted, and I'm not worried about, I'm talking about Gwinnett, because we're here in Gwinnett County, be sentenced in Gwinnett County, for what took place by a Gwinnett County judge with them prosecuting the case. And I think that's what's important. I'm not talking about City of Atlanta. I'm not talking about Loganville. I'm not talking about Jackson County. And I'm not talking about the other places that he's been arrested. Because Those are happening, that's in the record. That's in the record in the 404B. Well, what have they done?
Judge, I still fail to see the relevance of Mr. Holland's sentences. We're not here to sentence Mr. Holland.
Judge, she's made that clear, and she's had her time, she needs to sit down.
Continue.
Thank you, Judge. So what does it all add up to? Well, after this act occurred that Mr. McDonald was involved in, he's been arrested and charged with 2 different sets of felonies, and the court heard about it. One was a robbery, stalking, and various batteries involving his girlfriend. And then another one where he was aggravated stalking, again, for 2 counts. And he fled from the police, and you heard me cross-examine him about those, about the terror, and you saw his reaction at that time, about how he just smiled and laughed about it. And you heard about the grifting he was doing at the college, about the scam he was running at the college, and how he ran from the police there, and how he was charged with that, and how he was charged with obstruction, and how these things mounted up. State never sought to revoke his bond. You saw him testify how lighthearted he was, not exhibiting any of these things that his mother's testified to here today. You saw Mr. Bon Giovanni and how tensed up and he was. And he was denying all of this. He was still maintaining his innocence. He was still doing that. And the state, to this day, has never, ever sought to revoke his sentence on the basis that he did not testify truthfully. And that was part of his sentence, that he testified truthfully, and they've never done anything about it. So for all these cases pending, the court will see him in the probation revocations, everything that he was charged with, that is set forth in Defendant's Exhibit number 56, Judge. The whole time when he was arrested, you know, we had a hard time pinning him down about when exactly he was arrested at trial, but we finally got that date done with him. And lo and behold, Judge, on this last case right here, where they reduced it down to misdemeanors again, just like they did on the other felonies, the state of Georgia, represented by the District Attorney's Office of Gwinnett County, reduced it again. Felons to misdemeanors. And out of all that, from the time he was arrested in October, and he testified on that stand when I asked him, "You been offered any deals about this last case?" Nope, nope, nope. How about the district attorney's office? Nope, nope. Well, you can see from the sentence, it wasn't very long after this trial, he got it. He got his reduction down to misdemeanors, and the total amount of time he served in Gwinnett County for all these arrests that the court will see, all of them, probation revocations, everything, is 4 months and 17 days. That's what it adds up to.
Judge, Mr. Britt is mischaracterizing any deal that we would have made with Mr. Hollins, and at the time of trial, nobody had made any deals with Mr. Hollins.
Judge, she doesn't know that because there's supposed to be a Chinese wall that was built at the district attorney's office to keep her and the state's other assistant DA from knowing anything about those cases, and that was specifically done. So I don't think she knows what was or was not done.
There was no deal made by this district attorney.
Well, I understand.
But there was by other people in the district attorney's office, because there was a Chinese wall, and that is in the records, that was done in this case. She was not privy to it, but it was done by the DA's office of this state, in this county.
Judge, whether or not Mr. Hollins got a deal on that aggravated stalking was not part of any deal that either Ms. Henrich nor I made with him in exchange for his testimony.
I understand
Thank you.
But we don't know what he does, is what I'm saying.
that. understand what you're saying.
But it gets down to the fact, Judge, that we want 3 years to serve by this man. And this young man has served 4 months and 17 days. Mr. Bon Giovanni, he ain't done anything. He ain't done anything. He was the second man there. We respect the jury's verdict. I respect the jury's verdict. You know I have never questioned the jury's verdict. I respect them and I appeal it, but I respect the jury's verdict in this case. And that was a finding, and that's what you can sentence him with, Judge. But we have to deal with what we have and the people that are involved in this case. And I would also point out to the court in this case the fact of what the pre-sentence investigation. The state does not address that whatsoever. The community service, supervision, or probation, whatever they're called nowadays, they did an investigation. They talked to everybody. They examined. I sent them all the documents, police reports, I sent them everything they asked for. And they came up with work release only. Now, we would ask, and I would ask that I think this case is always warranted probation. I don't think that in any sense of the matter that he should be given any greater sentence than Mr. Bon Giovanni got. And I surely don't think he should get 3 years to serve in prison. I would urge that upon the court. And I would further object to the court awarding any restitution because we've never gotten any medical bills and there's never been any testimony about any medical bills. And so they've not proved that and they're not entitled to restitution. And we would object to that, Judge. So with that, Judge, I would ask the court to show the leniency that is merited in this system and let this young man and his wife get on with their lives and this family try to heal just like the other family needs to try to heal. Thank you, Judge.
Thank you, Mr. Brett. Well, I'm not going to get into a lengthy discussion of my time as a judge here, but I will make note that in 36 years, I've had a lot of opportunities to sit in this chair and render a sentence, and I take it very seriously. I don't try to craft a sentence without thoroughly reviewing everything that I have had made available to me from the state and the defense. I've reviewed my trial notes. I've reviewed the pre-sentence investigation that was requested by the state and the defense. I have taken note of the recommendation and a few things that were set forth in it. One of the things that I thought was quite interesting on page 8 in the last paragraph of the pre-sentence investigation reasons for the recommendation, the officer doing the investigation said, "I don't believe a prison sentence will serve any purpose, but other than be punitive and not rehabilitating." I do recall a lot of the testimony. I keep rather copious notes during the trial. I think there were 22 state's witnesses and 1 defense witness, as I recall. I take notes on what they testify about. I've reviewed those. I have also looked at the sentence that was imposed upon the co-defendant, Mr. Michael Bon Giovanni, and I have arrived at what I believe is a fair and appropriate sentence in this case. I will say that the pre-sentence investigation recommends sentence on count 1 of 10 years to serve first 24 months in work release and a balance on probation. It does recommend on count 2, violation of oath of office by a public officer, 10 years, and that's not correct. It can't be. There's a maximum of 5 years that can be imposed on that offense. So that certainly would not be considered. And then a 12-month work release on the count 3 battery misdemeanor. We got hit with COVID. It's affected every person in this United States of America, some more than others. One of the things that COVID does is it's highly contagious. And Georgia has just been ranked one of the top states that I just saw as of yesterday in the country for the spread of it. And confined settings are where it is most active and it is dangerous. I've taken all of that into consideration, and I've arrived at what I believe, as I say, is a fair and appropriate sentence in the case. Mr. McDonald, please rise, sir. The jury did return a verdict of guilty on 3 counts: aggravated assault, violation of oath of office, and battery. It is my duty and responsibility to impose sentence. The court will impose sentence under first offender. Your lawyer has explained to you the terms of first offender, and you understand everything he's explained to you about it, and you are requesting the court sentence you as a first offender. Then this sentence will be imposed as a first offender under OCGA 42-8-60. Query. Mr. Britt, did your client serve any time in jail before he was bonded out?
No.
No, was bonded out immediately?
There's no credit for
He was allowed to go in, we had to agree upon bond and.
No credit for anything, so. I will tell you now, I'm going to sentence this first offender, and the behavioral incentive date in his case will be November the 12th, 2023, in accordance with OCGA section 17-10-1. Count 1, aggravated assault. I will sentence 10 years. 11 months of that, I'm going to provide that you serve that on home confinement. I'm not going to put you in work release. I think that could be a very bad situation because people coming in, going out. I know the warden's done a great job in the correctional facility and in the work release facilities. But at this time, because of the nature of what Georgia is experiencing and our country is experiencing with this coronavirus, I feel home confinement is a better alternative. So that will be a 10-year sentence with 11 months to be served on home confinement with a GPS monitor. That has to be in place through probation within 3 business days of today. You will